Olympic gold medalist Caster Semenya and her legal team are taking her fight to compete to the European Court. Caster Semenya wants the European Court of Human Rights to find that her rights under the continent's Convention on Human Rights were violated when the Swiss Federal Court upheld the World Athletics regulations on female eligibility. Joining us now is Benedict Piri, founder and managing director from Jurisprudential and Specialist Counsel. Mr. Piri, a very good evening to you. Now, you are no longer part of Caster Semenya's legal counsel as we speak, but you were actually part of the team when all of this began. Now, if we're looking at Caster's timeline, in 2009, in July, she won the 800 meters at the African Junior Championships. A month later, in August 2009, she wins gold at the World Championships. But it looks like that's when it all started going wrong. We believe that this is when she unknowingly took a test, a gender test. What was that all about?
Yes, I think it became very apparent in the summation that the Swiss Federal Court released in refusing Caster's appeal of the decision for the Court for Arbitration for Sport, that in Berlin, she had been subjected to gender testing, which, at the time as a teenager wasn't fully aware of what was happening. And that gender testing was really on the basis of the IAAF at the time, which is now World Athletics, to facilitate her exclusion from participation in World Athletics. That obviously was followed by a lengthy process. I think it was about a year to a year and a half of back and forth engagements between us at the time as her legal team, as well as the IAAF and other parties to secure her return to World Athletics, which occurred. And now we've had another issue in the sense that the IAAF did amend the rules and regulations with respect to female participation in athletics to cater for what they call variations in sexual development.
So talk to us about the details of what the World Athletics body is advocating as far as levels of testosterone in female athletes. Why are they barring Caster Semenya from competing in races over 400 meters?
So the World Athletics essential contention or central contention is that testosterone is the main driver for athletic performance, and that elevated levels of testosterone, which occur in certain athletes with XY chromosomes and a condition of sex development, render them with an unfair advantage over other female athletes when it comes to performance. This is, from what I can gather, not necessarily a view that is shared by the scientific community as a whole. And in fact, it appears that the scientific community is skeptical of that assertion. And the evidence which was led by World Athletics at the CAS seems to suggest that these are merely observations rather than scientific proof. But be that as it may, the Swiss Federal Court was constrained to overturn that decision given the jurisdictional boundaries within which it operates.
So what are the merits of the case? What is the argument that Caster Semenya's team is putting forward to the courts?
The way I understand it is that essentially the issue really is that these regulations from World Athletics have facilitated an unwarranted and unnecessary non-consensual treatment and from a female athlete perspective. And that is a human rights question in the sense that it becomes a means to coerce a female athlete into participating. So in other words, you have to go through this level of reducing your testosterone for a period of 6 months and being subjected to checks on that respect to earn a right to compete. I think it's very clear why that is a human rights issue, because it goes very squarely to issues of privacy, to issues of dignity, to issues of bodily integrity, and in this case, to issues of the ability to make a living, essentially.
And also what it really flies in the face of is the fact that not everybody is created equal. There are some people with a natural, God-given propensity to excel in certain areas. So in some ways, their argument really says that everybody should be the same. Now, if you are born a particular way, it's not of your doing. You haven't, doused yourself. You haven't taken any sort of medication or any banned substance that allows you to perform in a way that gives you an unfair advantage. But talk to us about the prescription that they are wanting to put down, the fact that if she does indeed want to compete over 400 meters, that she has to take medication?
Yes, and the prescription is aimed at reducing the testosterone levels. According to World Athletics, their assessment, rather, if I can call it that, is that elevated testosterone levels in females of variations of sex development leads to enhanced performance, which confers an unfair advantage on other female competitors. And I think, that is a false premise. I don't believe that testosterone is a driver on its own, because, and it wasn't canvassed at the Swiss court, but there's also a question around what about male athletes with heightened levels of testosterone? So I think that it's really not a convincing argument, especially because, the scientific community doesn't rally around that argument. And over and above that, it seems to suggest that testosterone is something that doesn't belong in females, which I don't think we can adhere to or subscribe to.
Now, if you could take us perhaps through the reasoning why there's been such a back and forth regarding this with the World Athletics. In April of 2018, the World Athletics introduces the rules for female athletes regarding the high testosterone levels. In June of 2018, that rule is challenged by Caster Semenya. She loses that appeal in May of 2019, but appeals it at the Swiss Federal Supreme Court. And then in June, the Swiss court temporarily suspends the World Athletics body rules, and this allows Caster Semenya then to be able to compete. But then a month later, that's revoked, once again binding Caster Semenya and preventing her from competing. Why the back and forth? Why the seesaw in this matter?
And Tammy, to be fair, it starts almost a decade earlier, somewhere towards the end of 2008, 2009 or so. The IAAF had rules, and on the premise of which they conducted the gender verification tests on Caster in Berlin. Those rules were actually challenged by an athlete, Mrs. Duty, at the Court for Arbitration for Sport. And in the middle of that challenge, then these new rules that are now subject of the dispute were then enacted, right? And then obviously the back and forth that you have articulated now. I think it is a very difficult matter to land, in the sense that there's very clearly human rights issues on the one hand, and that has been a theme that both the Court for Arbitration for Sport and the Swiss Federal Court have acknowledged, that these are matters that do, on the face of it, violate human rights. But then the decision from their perspective has that it's more important to seemingly preserve fairness in sport, and that is actually a greater imperative in this instance. From a European cause for human rights perspective, the argument will be that the Swiss Federal Court has not given effect to the Convention for Human Rights, the European one, and that the Swiss Federal Court must then remedy its decision, because the human right is actually more important than this alleged argument around fairness in female sports.
So, Mr. Perry, is there a legal precedence for a case of this nature, whether it involves a male or a female athlete?
Yes, the Court for Arbitration for Sport does frequently adjudicate matters involving gender testing. I just made reference to Miss Duty. Oh, sorry, my lights just went off. I just made reference to Miss Duty.
Is that ESCOM or is that just you?
That is the automatic lights in the room. I'm here too long.
All right.
Yeah, there we go. I just made reference to Miss Duty's matter, and there has been enough of these matters that have gone through the Court for Arbitration for Sport, and certainly there has been a couple that have been also at the United Nations the European Court for Human Rights. So it isn't totally unprecedented, but I think this is probably the best time for the Court for Human Rights to develop jurisdiction in this respect. Jurisprudence.
Certainly a landmark case this is. And is there support from the African continent? And what has been the word from the sporting fraternity?
By my reading, there's great support for Caster. And certainly there's great support from the medical fraternity. You know, a global organization of doctors has come out in, scathing on these regulations and has asked its members not to implement them. The United Nations also scathing on these regulations. I think it's very clear that they really do strike at fundamental human rights, and it doesn't appear that they can be sustained. So there is a rallying around, which I think is actually quite is great for Caster in this instance.
Mr. Perry, thank you so much for your insight, as well as the historical knowledge behind the Caster Semenya fight for her human rights. That's Mr. Benedict Perry, founder and managing director from Youth Prudential and Specialist Counsel.